My name is Elena Voss. I'm 33 years old, and the first time a lawyer finally called me back, my father had already been moved into a different room without my knowledge, and my brother had already spent 4 months explaining to everyone in our family why I was the problem. Welcome back to Calm Verdict Stories, where quiet people finally say the things that took years to say, and families learn what waiting can actually cost and what it can actually save. If stories like this find you at the right time, drop a comment below and subscribe, because I have a feeling some of you have already typed the words, "call a lawyer," into a comment section on a video exactly like this one, certain it was the obvious answer. I want to walk you through why it wasn't, at least not the way you're picturing it, and what it actually took to do this right instead of just doing it fast. I'm a paralegal. 11 years now, mostly in elder law and guardianship matters, which sounds like a small, quiet corner of the legal world, until it becomes your own family's corner. My job, most days, is reading the exact documents that decide whether an elderly person keeps control of their own life or loses it to someone else's signature. I know what a valid power of attorney looks like. I know what a court considers clean evidence versus what it considers a daughter's suspicion. I know, better than almost anyone I've ever met outside my own office, exactly how slow and exactly how procedural the system is that's supposed to protect people like my father. That knowledge is the entire reason I didn't do what every single person watching this is about to tell me, in the comments, that I should have done on day one. I want to tell you a little about how I ended up in this specific corner of the law, because it matters to how carefully I moved once my own family became the case file. I fell into elder law almost by accident, taking a temp position at a small firm during my second year of paralegal school, simply because it paid better than the alternatives, and I stayed for a reason I didn't fully understand until years later, sitting across from my first genuinely contested guardianship case, watching a sibling dispute unfold almost exactly like this one, except it wasn't mine yet. And I remember thinking, even then, thank God I'm not that family. The universe, apparently, has a particular sense of humor about sentences like that. My father is Walter Voss, 74 years old when this started, a retired high school shop teacher, the kind of man who could fix anything with his hands and very little with his words. My mother died 11 years ago, right around the time I started this career, which I've never quite believed was a coincidence. Some part of me choosing a field that let me understand, professionally, the kind of paperwork that had swallowed her final months. After she passed, my father lived alone in the house I grew up in, stubborn and mostly fine, until 3 years ago, when the first signs of memory trouble started showing up in small, forgivable ways. Misplaced keys, a missed bill, a story told twice in the same conversation without him noticing. My older brother, Marcus, is 37, and he has always been the one our father trusted with what our family calls the big stuff, the same way some families designate one child as the responsible one without ever holding an actual vote about it. Marcus lives 20 minutes from Dad's house. I live 2 states away, which by the unspoken math of my family has always counted against me, regardless of how many hours I've spent on the phone, regardless of how many flights I've taken on short notice, regardless of anything except the plain geographic fact of where my job happened to land me after college. I think about a specific Thanksgiving, maybe 6 years ago now, when my father's transmission went out the week before the holiday, and Marcus, without asking anyone, took it upon himself to trade in the old truck for a newer one, using a chunk of Dad's savings, and framed it at dinner as a wonderful surprise he'd arranged for their father. Watch him get emotional, everybody. I remember sitting at that table doing quiet math in my head, the way I always seem to end up doing at family gatherings, and thinking that a decision that size probably deserved a conversation with more than one adult child in the room. I didn't say anything. Marcus has always had a gift for making his decisions feel like gifts, and mine feel like interference. And by that point in my life, I'd stopped being surprised by which one got applause at the table. I also want to tell you about my mother, briefly. because she matters to how I understand all of this now. She was, in her own quiet way, the one who kept our family's actual books, the real ones, not the version anyone saw. After she died, I found a small ledger in her nightstand, handwritten, tracking every loan she'd ever given either of us, repaid or not, dating back decades. Marcus's column was longer. Mine had exactly one entry: $400 for a car repair in college, paid back within 2 months, underlined twice in her own handwriting, the way she underlined things she was proud of. I think about that ledger more than I probably should. It taught me, long before any of this started, that my family has always kept 2 sets of records, the spoken one and the real one, and that I was usually the only person who ever bothered reading the real one all the way through. When our father's memory started slipping in ways that were no longer forgivable, when a neurologist finally used the word dementia out loud in a small exam room I wasn't in the room for, it was Marcus who sat with him for the power of attorney paperwork. Nobody called me before that appointment. Nobody called me after it either. I found out 3 weeks later, the way I find out most things now, in a family group text, a single line from Marcus that read, "Got Dad's affairs squared away. Don't worry about anything." I want you to remember that sentence, because it is the exact sentence that started all of this, and it is the exact sentence I would spend the next 1.5 years learning not to trust. I did what any reasonable person does in that position. I asked to see the documents. Marcus told me it was all standard, nothing to worry about. He'd handled it with a lawyer friend of his, everything by the book. I asked, gently, for a copy, the way you'd ask a colleague for a file you're entitled to see. He said he'd send it over. He didn't. 3 separate times over the following 2 months, I asked again, and 3 separate times, the request evaporated into some version of, "I'll get to it," or, "Dad's fine. Why are you making this a thing?" The second time I asked, over the phone on a Sunday evening, he actually laughed, a short, surprised sound, and said, "You're doing the lawyer thing again, aren't you, Elena? Reading everything like it's a case file." I told him I just wanted to see what Dad had signed, that it seemed like a reasonable thing for his other adult child to want. He said, in a tone I recognized from every disagreement we'd had since childhood, a tone that made whatever I wanted sound slightly unreasonable just by describing it back to me. "I don't have time to play messenger between you and a lawyer's office right now, Elena. I'm the one actually here." I let that land the way I always seem to let his comments land, quietly, without a rebuttal, filing it away instead of arguing with it, because arguing with Marcus in the moment has never once, in 33 years, produced anything except a longer, angrier version of the same conversation. I want to be honest with you about where my head was during those 2 months, because it matters to everything that came after. I was not yet suspicious of theft. I was suspicious of exclusion, which is a much smaller, much more forgivable feeling, and one my family has trained me to swallow my entire life. I told myself the story every dutiful, geographically distant daughter tells herself in that position. He's overwhelmed. He's doing the actual daily work. I'm asking for paperwork from 2 states away while he's the one driving to appointments. I believed that story completely, for a while, because believing it was easier than the alternative, and because it fit so neatly into the shape our family had already carved out for both of us decades earlier. My father's decline accelerated faster than any of us expected. By early spring, he could no longer safely live alone, and the family, meaning primarily Marcus, made the decision to move him into a memory care facility about 15 minutes from Marcus's house. I supported that decision completely. I still do. My father needed round-the-clock care that none of us, honestly, could provide on our own, and the facility Marcus chose had a good reputation, clean reviews, a waiting list even, which Marcus mentioned more than once as though it were evidence of how well he was handling things. I flew in for the move. I helped pack the house. I found myself, in the middle of folding my father's old flannel shirts into a suitcase, more grateful to Marcus than suspicious of him. because someone had clearly been managing something enormous while I'd been 2 states away managing my own life and quietly resenting being left out of the paperwork. The house sold 4 months after that, faster than I expected, and that's the moment the numbers started not adding up. I asked, as Dad's other adult child, what the proceeds from the sale were being used for, beyond the obvious, beyond the facility's monthly cost, which I already knew from a brief conversation with the admissions coordinator during the move. Marcus told me it was complicated, that there were medical bills I didn't know about, home repairs that had needed doing before the sale, a dozen small explanations stacked on top of each other, each one individually plausible, together forming a wall I couldn't quite see through. I asked for an accounting. He told me, almost word for word, the same sentence my mother used to say to me as a child whenever I asked why Marcus got something I didn't. "You don't need to worry about the details, Elena. Dad's taken care of." I remember exactly where I was standing when he said that, in my own kitchen, phone against my ear, staring at a calendar on the wall with my father's facility visit schedule written in my own handwriting, and feeling something shift very slightly, not into certainty yet, but into a kind of attention I hadn't been paying before. I asked him a direct, specific question, the kind I ask professionally a dozen times a week without a second thought. What was the final sale price? And what were the closing costs? He told me he didn't have the numbers in front of him. I asked when he might. He said he'd have to check with the title company, and then, almost as an afterthought, added, "Why does this matter so much to you right now? Dad's settled, he's safe, isn't that the point?" I told him the point was that I was still his daughter too, and that being his daughter came with the right to understand what was happening to his money, not just his mailing address. Marcus didn't respond to that. He said he had to go. Someone was calling him on the other line, and the call ended before I'd finished my sentence, which I would later recognize as a pattern, not an accident. Here's where I want to be completely honest with you, because this is the part of the story where the comments always split into 2 camps, and I've read enough of these videos myself to know exactly what both camps are going to say. Camp 1 says, "Why didn't you call a lawyer the second he stopped sending you the documents?" Camp 2, smaller, quieter, usually shows up a little later, understands exactly why I didn't. I want to walk you through the actual reasoning, slowly, because it is the single most important part of this story, more important than any dollar figure I'm about to give you. At the point where Marcus stopped answering my requests, I had no legal standing whatsoever to demand anything. None. My father, while declining, had not yet been declared legally incapacitated by a court. The power of attorney Marcus held, whatever its actual terms turned out to be, was valid on its face, executed with an attorney present, which meant that unless I could show actual, documented misconduct, any attorney I hired would be walking into a courtroom with nothing but my word against my brother's, in a state that, like most states, starts from a strong legal presumption that an agent under a valid power of attorney is acting in good faith. I know this because it is, professionally, exactly the kind of case I have spent 11 years watching other families lose, spectacularly and expensively, when a sibling rushes into court with suspicion instead of proof. There's a second reason, one that took me longer to admit even to myself. If I filed a petition too early, alleging financial misconduct I couldn't yet substantiate, and lost, the consequence wasn't simply an embarrassing court date. It could permanently poison any future guardianship proceeding, could brand me in the court's eyes as the difficult, litigious daughter making unfounded accusations against a caregiving brother, which is precisely the narrative Marcus had already been building for months inside our family, quietly, one comment at a time, to our aunts, to our cousins, to anyone who would listen. If I acted too fast and too loud, I would hand him exactly the story he needed. And worse, far worse, an ugly, premature legal battle risked disrupting my father's placement itself, the facility, the routine, the caregivers he was slowly, fragile as it was, starting to trust. I was not protecting my pride by waiting. I was protecting the one thing in this entire situation that could not be undone if I got it wrong. My father's stability. So instead of calling a lawyer that spring, I did the thing 11 years of paralegal work had actually trained me to do. The unglamorous thing. The thing that doesn't make for a satisfying comment section reply. I started building a file. I requested, formally, in writing, a copy of the power of attorney document itself from the attorney's office listed on some old paperwork of my father's I still had access to, citing my status as his adult daughter and next of kin. That request alone took 6 weeks to produce a response. And when it finally arrived, I read it 3 times before I let myself react to what I was looking at. The document was a durable, general power of attorney. Broad, standard language. Nothing unusual on its face. Executed the same week as that appointment I hadn't been invited to. But buried in the standard language was one clause that was not standard at all. A provision granting Marcus authority to make gifts of the principal's assets, to himself, without limitation. A clause most attorneys I know would flag and discuss carefully with a client before including, given exactly the kind of situation I now found myself in. I sat with that clause for 3 days before I told anyone I'd seen it. The same way, I'd later learn, other people in situations exactly like mine have sat with their own discoveries. I want to be honest, because it's important. I did not immediately understand the full weight of what that clause meant. I understood it meant Marcus had broad legal cover for whatever he'd already done. I did not yet understand how much he had actually done. I started requesting bank records next. The ordinary way. The boring way. The way that doesn't feel like justice while you're doing it. My father still had a small joint account with me from years earlier, opened when I was in college for emergency purposes. One he'd never closed, and which gave me limited, legitimate visibility into a fraction of his finances without needing anyone's permission at all. It wasn't the full picture, not even close, but it was enough to start a timeline. Deposits from the house sale, landing exactly where I expected. Withdrawals, several of them, in amounts that didn't correspond to anything on the facility's published fee schedule, which I'd requested and received directly, in writing, from the admissions office. No permission from Marcus required. I want to describe the process of that summer honestly, because it was slower and more tedious than anything a courtroom drama would show you. Most evenings after work, I'd sit at my kitchen table with a legal pad and a folder, cross-referencing bank statements against the facility's fee schedule line by line, the way I do it for actual clients 5 days a week. Except this time, every entry had my father's name on it instead of a stranger's. I built a simple spreadsheet: month, expected cost, actual withdrawal, difference, and watched a column labeled difference grow steadily larger every month. Never explained, never matching a receipt, never matching anything except a pattern I recognized immediately from cases that had crossed my own desk over the years. Cases where I'd sat across from the family member on the receiving end of exactly this kind of scrutiny and thought, privately, how did nobody catch this sooner? Priya Nair, the facility's social worker, became an accidental ally during this stretch, though I want to be clear I never once asked her to take a side. And she never did, not officially. She simply answered the questions I was entitled to ask as my father's other adult child, plainly and promptly, in a way Marcus never had. What's the current monthly rate? Has the account ever gone past due? Who is listed as the primary contact for billing? Small, boring, procedural questions that, added together, built a second timeline running parallel to my own. One that came from an entirely independent source and matched mine almost exactly. By midsummer, I had built, on my own kitchen table, over the course of 4 months, the kind of file I have watched 100 clients build in my own office, one document at a time, patiently, without ever once tipping their hand to the person on the other side of it. Copies of the power of attorney with the gifting clause highlighted. The facility's actual published costs, month by month. Withdrawal records from the joint account showing amounts that exceeded those costs by a significant recurring margin. And, near the end of that summer, the piece that finally moved this from suspicion into something else entirely. a real estate transaction record showing that a portion of the house sale proceeds, nearly $90,000, had been used as a down payment on a lake property, titled solely in Marcus's name, purchased 6 weeks after our father's house closed. I called Marcus directly before I called anyone else, because some part of me, even then, 4 months into building a case against my own brother, wanted to give him the version of this conversation where he had an explanation I hadn't thought of. I asked him plainly what the lake property was. He was quiet for a moment, and then he told me it was an investment, on Dad's behalf, that Dad had actually suggested it himself, years ago, before the diagnosis, that he was simply following through on what our father would have wanted. I asked him why, if that were true, the property was titled in his name instead of our father's, or in some kind of trust. He got defensive fast, faster than I expected, his voice rising in a way I'd rarely heard from him. Do you have any idea what it's like, Elena? Driving out there 3 times a week, dealing with the facility, dealing with his moods, dealing with all of it, while you call from 2 states away asking for spreadsheets. I told him I understood it was hard, genuinely, and that nobody was disputing the work he'd done managing the day-to-day. But hard work, I said, doesn't come with a lake house titled in your own name. He went quiet again, and I could hear him breathing on the other end. And then he said, quieter now, almost pleading, "You're really going to do this to me, after everything I've handled?" I told him I wasn't doing anything to him. I was asking a question any reasonable court would eventually ask, and I would rather ask it now, as his sister, than have a judge ask it later, as a stranger. He told me I was overcomplicating things the way I always did. He said the exact sentence I had been bracing for since spring. "You don't understand how this stuff works, Elena." I told him, very calmly, that understanding exactly how this stuff worked was my entire professional life, and that a $90,000 down payment titled in the agent's own name, made under a broad gifting clause, 4 months after his principal moved into memory care, was not an investment story a court was going to find charming. He hung up on me. That was the last real conversation the 2 of us had before everything that came after. That night, I sat with the phone in my hand for a long time after the call ended, replaying it, and I noticed something I hadn't fully registered in the moment. He never once said the word no. He never once said, "That's not what happened." Every sentence he offered me was a justification for something, not a denial of it. And I have learned, in 11 years of reading people who don't want to answer questions, that justification without denial is its own kind of confession, just dressed up in better clothes. I want to pause here and tell you what those 4 months actually cost me, because I think it's the part nobody who's typing "call a lawyer" in the comments has had to sit with. It cost me my aunt's Sunday phone calls, which slowly turned into gentle interrogations about why I was making things difficult for Marcus during such a hard time. It cost me a cousin's wedding, where I could feel the room's temperature change slightly whenever I walked into it, because Marcus had clearly been managing the narrative in rooms I wasn't in, the same way he'd managed the paperwork in a room I wasn't in. It cost me, more than once, lying awake wondering if I was wrong, if I was the difficult one, if 4 months of quiet, careful documentation was actually just 4 months of me failing to protect my father while I filled out spreadsheets instead of acting. I remember one specific night in June, sitting at my kitchen table at nearly midnight, spreadsheet open, a cold cup of tea forgotten beside my laptop, when I genuinely considered deleting the whole file and simply letting it go, letting Marcus have whatever he'd already taken, telling myself Dad was safe and fed, and that was supposedly the only thing that mattered. I called a friend from law school that night, someone who'd gone into family law instead of elder law, just to talk it through, not for advice exactly, just to hear another voice say out loud that what I was feeling had a name and wasn't unreasonable. She listened for almost an hour, and then said one sentence that kept me at that table instead of closing the laptop for good. "You're not being paranoid, Elena. You're being thorough. And there's a version of this where thorough is the only thing that saves him. But I also want to tell you what those 4 months bought me, because this is the part of the story that actually matters. They bought me a file an attorney could use the moment I finally walked into an office, Instead of a file an attorney would need 4 more months to build from scratch, while my father's situation continued unsupervised. They bought me the ability to walk into that first consultation and lay out dates, documents, and dollar amounts instead of a feeling. And they bought me something I didn't fully appreciate until much later. The difference between filing a guardianship petition that looks like a grieving daughter's guess and filing one that looks like exactly what it was, a documented pattern a court could not reasonably ignore. Colette told me once, months into working together, that she can usually tell within the first 10 minutes of a consultation whether a case is going to settle quickly or drag on for years, and that the difference almost never comes down to how angry the client is. It comes down to how much homework they did before they ever sat down in her office. I finally called a lawyer in late August, 5 months after that first unanswered request for paperwork. And I want to be precise about why that specific week, because it wasn't the lake property alone that pushed me over the line, though it came close. It was a phone call from the facility's social worker, a kind, careful woman named Priya Nair, who mentioned, almost as an aside during an unrelated conversation about my father's care plan, that his account with the facility had gone 30 days past due on the previous month's balance, despite the withdrawal records I already had showing more than enough money moving through his accounts to cover it several times over. I remember standing in my kitchen, holding the phone, asking Priya to repeat the number, certain I'd misheard her, because I had watched, on paper, tens of thousands of dollars move out of my father's accounts that summer, and the idea that his own facility bill, the actual roof over his head, could simultaneously be 30 days behind, felt like two facts that couldn't possibly exist in the same reality. She told me gently that these situations happen more often than people think, that families sometimes assume a power of attorney means bills are automatically being paid, when in practice, it just means one person has the authority to decide whether they get paid at all. She asked, carefully, whether everything was all right at home. In the kind, professionally neutral way social workers ask questions they already suspect the answer to. I told her I wasn't sure yet, but I was about to find out. That was the moment the story stopped being about a lake house and started being about whether my father's actual care, the thing all of this was supposedly protecting, was even being paid for at all. I called the facility's billing office myself that same afternoon, using my limited authority as an emergency contact on file, and confirmed what Priya had told me. The balance was covered within the week, quietly, by me, out of my own account. Because whatever else was true, whatever legal process still lay ahead, my father was not going to sit in a facility with a past due notice attached to his name, while his own son's lake house sat fully financed 40 minutes away. The attorney I found specializes almost exclusively in elder financial exploitation and guardianship disputes. A sharp, unhurried woman named Colette Ferris, referred to me by a former coworker who'd watched a case just like mine collapse years earlier because the sibling involved had rushed in too soon with too little. I sat in Colette's office with a banker's box, an actual banker's box, the kind you'd use for a real trial, containing 5 months of dated, organized, tabbed documentation. She went through it slowly, the way Renata had gone through mine in a different story, flipping back through certain pages twice, and about 40 minutes in, she set the folder down and said the sentence I had been waiting 5 months to hear from someone who wasn't me. Elena, this isn't going to be a fight about whether you're allowed to ask questions. This is a petition for an accounting and a suspension of the agent's authority. And with what you've brought me, we can likely get an emergency hearing within 2 weeks, not 2 years. I asked her, because I needed to hear the honest version, whether the 5 months of waiting had helped or hurt us. She looked at me for a moment and said something I've repeated to myself many times since. If you'd come to me in April with nothing but a bad feeling and an unanswered text message, I would have told you to wait exactly as long as you did, and to spend that time exactly the way you spent it. The waiting wasn't the delay. The waiting was the work. She told me something else that day, too. Something I didn't fully understand until much later, sitting in the courtroom, watching Marcus's young associate flounder for an answer he clearly didn't have. She said that in her experience, the families who rush into her office in week 1, angry and undocumented, almost always end up settling for less, not because their claims are weaker, but because a rushed petition gives the other side an easy narrative, an emotional sibling making accusations, and once a judge starts hearing the case through that lens, it's nearly impossible to fully undo, even once the real evidence eventually surfaces. Families who wait and document, she said, however painful that waiting is, walk in with a story the other side simply cannot spin. I asked her how she knew the difference, in advance, between someone who was wasting time and someone who was doing exactly what I'd been doing. She said, honestly, sometimes she doesn't know until the first meeting, until she watches whether someone shows up with a feeling or a file. I showed up with a file. That, she told me later, more than anything else, was the entire reason we only needed 14 days. The emergency hearing happened 3 weeks later. I want to walk you through it because it's the part every version of this kind of story tends to rush past. And it's the part that actually decided everything. I sat in the courtroom that morning in a plain gray suit I'd bought specifically for the occasion. Colette beside me with the banker's box on the table between us. And I remember thinking, absurdly, that the room looked smaller than I'd imagined it would. More like a conference room than the marble hallway of my imagination. Fluorescent lighting, a court reporter setting up her machine with the bored efficiency of someone who does this every single day. Marcus showed up with his own attorney, a young associate who looked, I'll admit, a little unprepared for the volume of what Colette laid in front of the judge. Marcus wouldn't look at me when he walked in, which surprised me more than I expected it to, after everything. Bank statements, the facility's fee schedule, the highlighted gifting clause, the property deed, a timeline built month by month, each entry cross-referenced against the last, printed, tabbed, 3 copies, one for the judge, one for opposing counsel, one for the record. Colette walked through it methodically, page by page, date by date, letting the judge ask questions whenever she wanted, rather than rushing past them, which I understood, watching it happen, was itself a kind of strategy. Patience as a form of credibility. Marcus's attorney argued, predictably, that the power of attorney was valid, that gifting clauses were not unusual, that Marcus had been managing an extraordinarily difficult situation alone, while I, and here the associate actually used this phrase, lived out of state and offered opinions from a distance. The judge, a woman with silver hair and reading glasses pushed low on her nose, looked up at that line and asked, mildly, whether living out of state disqualified a daughter from asking to see her father's bank statements. The associate did not have a good answer for that. Colette did not raise her voice once. She simply walked the judge through the numbers, the same way I'd watched her walk through them with me in her office, patiently, without embellishment, and let the arithmetic do what arithmetic always eventually does in a room like that. The judge suspended Marcus's authority under the power of attorney that same day, pending a full accounting, and appointed a temporary guardian ad litem, an independent third party, to review the entire financial history of the past year and report back to the court. I remember sitting in that courtroom, in a wooden pew that had clearly seen 100 family disputes exactly like ours, feeling something I hadn't expected to feel at all in that moment, which was not triumph. It was relief. Plain and simple, the specific relief of finally having someone with actual authority looking at the same numbers I'd been looking at alone on my kitchen table for 5 months, and agreeing that they didn't add up. The full accounting took another 4 months to complete, because these things, I've learned, professionally and personally now, never move as fast as anyone watching from the outside wants them to. The guardian ad litem assigned to the case was a retired probate attorney named Howard Chen, methodical almost to a fault, the kind of man who called me twice just to confirm the exact date on a single receipt before including it in his report. I appreciated that thoroughness more than I expected to, even when it meant more waiting, because I understood, better than most people watching this could, that thoroughness was the entire point. That a 52-page report built slowly and carefully would hold up in a way a rushed one never could. When it was finished, the report confirmed almost everything I'd already found and added several things I hadn't. Beyond the lake property, there were transfers to a business account Marcus had opened the same month as the power of attorney appointment, described in the paperwork as caregiving compensation. Though no formal caregiving agreement had ever been filed with the court, no hours logged, no rate established, nothing but a recurring transfer with a convenient label attached to it. There was a car, purchased in Marcus's name, 4 months after the house sale. A detail I hadn't uncovered myself, sourced instead from a dealership financing record Howard had subpoenaed as part of the investigation. There was a family vacation, taken by Marcus and his wife the same month our father's facility account had gone 30 days past due, charged partly to a card linked to one of our father's accounts. And there was, underneath all of it, the number that finally made the abstraction of all this concrete for everyone in my family who had spent the spring calling me difficult. Just under $140,000 moved out of my father's assets over the course of 8 months against a documented caregiving relationship that consisted, in practice, almost entirely of the initial appointment where the power of attorney had been signed. I read that report alone in my apartment the night it arrived, start to finish, twice, and I remember feeling something I hadn't expected after everything, which was grief, plain and uncomplicated. Not for the money, but for the version of my brother I'd apparently been mourning without realizing it. The one who used to teach me to ride a bike in the same driveway where he later, apparently, decided our father's trust was simply another resource to be managed on his own behalf. Marcus did not go to prison. I want to be honest about that too, because these stories don't all end the same way. And I think pretending they do is its own kind of dishonesty. Financial exploitation of a vulnerable adult in our state sits in a strange legal territory, sometimes prosecuted criminally, more often resolved civilly, through restitution and guardianship reform, unless the pattern is severe enough or repeated enough to draw a prosecutor's direct attention. Colette explained this to me plainly, weeks before the final ruling, sitting across from me in her office with the same patient tone she'd used from the very first meeting. Criminal referral was possible, she said, and she would support it fully if I wanted to pursue it, but it would mean years, potentially, of additional proceedings, additional testimony, additional exposure for our father, who would likely need to be assessed for his own competency to testify at some point in the process, a prospect that filled me with a specific kind of dread I hadn't anticipated. I sat with that decision for 2 full weeks, the way I'd sat with almost every decision in this entire ordeal, weighing what more time and more fighting would actually buy, against what it would cost the one person all of this was supposed to be protecting. I chose the civil path, deliberately, and I want to be honest that I still turn that decision over sometimes, wondering if a version of me with less exhaustion left in her would have pushed for more. What Marcus faced instead was a court order requiring full restitution, structured repayment over 5 years, permanent removal as our father's agent under any future power of attorney, and the appointment of a professional independent guardian, unrelated to either of us, to manage our father's remaining assets and care decisions going forward. I was offered that guardian role myself, first by Colette, gently, almost as a formality, and then, more directly, by Howard Chen, who told me candidly that courts generally prefer a family member in that position when one is available and willing. I declined it, deliberately, after several sleepless nights turning the offer over, because I understood, from 11 years of watching exactly these situations from the other side of the desk, that a family member managing another family member's finances, even a well-intentioned one, even one who had done everything right, was precisely the structure that had made this entire nightmare possible in the first place. I did not want to become, 5 years from now, tired and overextended and quietly resentful, the sibling somebody else eventually had to build a file against. The professional guardian the court appointed instead is a woman named Diane Okafor, efficient and entirely unsentimental in exactly the way this situation required, who sends me a written accounting every single quarter, unprompted, a habit I've come to find more comforting than almost anything else that's happened since this all began, simply because nobody ever has to ask her for it twice. My father does not fully understand what happened, And in some ways, I've made a kind of peace with that being a mercy rather than a loss. On good days, he still remembers the shop class he taught for 31 years, still remembers my mother's laugh, still asks me, every single time I visit, whether I'm eating enough. The way fathers apparently never stop asking, regardless of how much of the rest of the world they've lost track of. I have not told him the full story of what his own son did with the money from his house. I don't know if I ever will. Some kinds of protecting don't end just because the paperwork is finally settled. There was one afternoon, a few months after the hearing, when he asked me, out of nowhere, where Marcus had been lately, and I told him Marcus was just busy, and he nodded slowly and said, "He was always the one running around, wasn't he?" and went back to his coffee. And I sat there wondering how much of the truth was already somewhere inside him, unreachable now, filed away in a place even the best guardian ad litem in the world could never subpoena. Marcus and I do not speak. Not out of anger anymore, though there was plenty of that for a long while, but because there is genuinely nothing left between us that a conversation could repair. He sent one email, about 2 months after the restitution order was finalized, 3 paragraphs long, apologizing in the specific, careful way people apologize when they're more sorry about consequences than about what caused them. He wrote that he'd never meant for it to become what it became, that it had started small and grown before he realized it, that he hoped someday I could understand the pressure he'd been under. I read it twice and did not respond. I've thought about that email more than I expected to, mostly because of what it didn't contain. No mention of our father by name, no mention of the lake property, no mention of the vacation. Just a general weather-shaped regret aimed at the situation, rather than at any specific thing he'd actually done. My aunt, the one who spent that spring gently questioning why I was making things difficult, called me the week the Guardian ad litem's report became part of the public record, and said only, "I'm sorry, Elena. I didn't know." I told her I understood why she hadn't, because Marcus had made very sure nobody did, for exactly as long as he possibly could. I don't hold it against her. I do think about it, though, every time someone in a comment section tells a woman like me that the answer was obvious and immediate, and that anyone who waited must have had something to hide. My cousin, the one whose wedding I mentioned earlier, the one where I could feel the room's temperature change, texted me a single line a few weeks after the hearing. I should have asked more questions that day instead of just watching. I told her most people don't know they're watching a performance until someone hands them the receipts. Here's what I actually want you to take from this, if you take nothing else. The people telling you to call a lawyer immediately are not wrong that you should eventually call one. They are wrong about the timeline, and they are wrong about what waiting means. Waiting is not the same as doing nothing. For 5 months, I built the exact file that turned a suspicion nobody would have believed into an emergency hearing that took 14 days to resolve instead of 14 months. If I had walked into a courtroom in April with nothing but a bad feeling, I believe, professionally and personally, that I would have lost. And worse, I believe my father's placement, the one stable thing in an otherwise collapsing situation, would have been the casualty of that loss. The system that is supposed to protect vulnerable people moves on evidence, not urgency. And learning the difference between those two things, the hard way, over the worst 5 months of my adult life, is the only reason my father has anything left at all. I still work in elder law. I go back to that job every single week now, with a version of empathy I didn't have before any of this happened, sitting across from other sons and daughters who come into my office with a shoebox of receipts and a look on their face I recognize immediately, because I used to wear it myself, on my own kitchen table, at 11 o'clock at night, wondering if I was doing this right, or doing it at all. I've started doing something I never used to do before this. In those first consultations, before we even open the shoebox, I tell them, plainly, that the waiting they've already done, the months they've spent feeling guilty for not having called sooner, were probably not wasted, and that if they'd come to me with nothing but a feeling, I'd have told them to go do exactly what they'd already been doing. I watch something in their shoulders change, almost every time, when they hear that. The same thing I imagine happened in my own shoulders the day Colette said it to me. Colette and I still talk occasionally, mostly professional courtesy calls about unrelated cases now, though she checked in personally, unprompted, about 6 months after everything settled, just to ask how my father was doing. I told her about the birdhouse story, the welded upside-down one he tells almost every visit now, and she laughed, genuinely, and said that was the kind of update she almost never gets to hear at the end of a case like this, because most families she works with are still too exhausted, a year out, to notice the good stories again. I think about that a lot. How much of this entire ordeal was really just a fight to get back to the point where a birdhouse story could be funny again, instead of freighted with everything underneath it. We have a small, quiet routine now, my father and me, on the Saturdays I fly in. I bring him coffee from the same diner he used to take my mother to, and we sit in the courtyard at the facility, and he tells me, most weeks, some version of the same story about a student who once welded a birdhouse entirely upside down and refused to admit it, and I laugh every single time as though I'm hearing it for the first time, because in the way that matters most, I am, every week, hearing it from a man who is still, somehow, exactly himself in the moments that count. Diane, the guardian, joins us for coffee sometimes, when her schedule allows it, and I've noticed my father has started greeting her the same easy way he used to greet Marcus, asking her about her drive, remembering, somehow, in whatever way his memory still lets him keep track of who shows up and who doesn't, that she is one of the people who comes. I don't know if he understands, on any level, what she actually does for him. The quarterly statements, the careful, unsentimental oversight that Marcus's version of care never once provided. I don't think he needs to understand the mechanics of it. I think, in the end, all he's ever really needed to know is that someone keeps showing up, and that whoever that someone is, this time, is finally telling him the truth. That's my story. One unanswered request for paperwork, 5 months of quiet, careful documentation nobody around me understood I was doing, and one emergency hearing that only took 14 days because I refused to walk in with anything less than the truth. Fully built, fully dated, fully mine. If you've ever been told you were overreacting for simply asking to see the paperwork, tell me in the comments, because I read every single one. And I promise you, the waiting is not always the mistake people assume it is. And if someone you know is quietly building a file right now instead of making noise, send them this. Because sometimes, the most important thing you can tell someone in the middle of it is that the waiting is the work. Subscribe to Calm Verdict Stories, and I will see you in the next one.